So I'm here with my colleagues, Greg Bush and David.
Hi, everyone.
Tsai. And so we're just going to jump right into it. And so what we're going to talk about is some of the updates during the pandemic in terms of interesting case law. So David's going to start us off with talking about termination practices and potential liability. Greg's going to cover constructive dismissal. Greg assigned to me the really boring cases about enforceability of termination clauses and all the bad news. So I'm the bad news person. And then David's got a great case to end the session with that's just full of all sorts of craziness. So it'll be kind of fun. So without further ado.
Yeah, absolutely. Well, if you're like me, you need a lot of caffeinated beverages or things to get yourself going in the morning. But easing into the process, we're going to go off and talk about termination practices, potential liability, which I think is a topic that's near and dear to all of us in terms of what we do in the HR landscape. And so the goal really is to kind of talk about three key cases, all of which have something to offer in terms of helping you take a deeper reflection on your current HR practices around termination, and hopefully it'll be a topic to ease us into the day. I find terminations to be one of my favorite things to assist clients with because it's challenging and it also involves a lot of sensitivity, but we get through it, and these cases help further illustrate what we need to do to do an effective job at a termination. So in terms of, the first case, which is the Russell versus the Brick Warehouse. This is the first of the three cases that we're going to talk about where it really demonstrates how important it is for everybody in conducting termination to demonstrate the utmost good faith when executing the actual terminations with a view towards minimizing the risks of damages for bad faith conduct. So in this first Russell versus Brick Warehouse case, it's a seemingly standard case dealing with wrongful dismissal. We have a court awarding 24 months notice to a 57-year-old senior supervisor with 36 years service. So that part's pretty standard, not unexpected to have 2 years of notice awarded. But the surprising part of this case was the fact that the court also awarded $25,000 in moral damages. And that was as a result of certain events that followed the termination. So in this case, essentially, what the company failed to do was tell the plaintiff, Mr. Russell, that if he did not accept their offer, which was in excess of the statutory minimums, they would nevertheless pay him his statutory minimums. The judge viewed that this was a serious defect to the termination letter, as it implies that employees will know that they can demand their statutory entitlements upon rejection of a separation offer. And this defect reflected a failure by the company to deal fairly with the individual. So by failing to include this provision in the termination letter, the company was viewed by the court as being not honest and forthright with the employee. There was also some delay in this case about ultimately paying out the statutory entitlements when no release was executed, and which combined with the evidence that was provided during the actual litigation process about the individual's mental distress, that resulted in the court awarding this $25,000 in moral damages and taking the position that the company lacked transparency and fair dealing in the manner of terminating his employment. So from a takeaway perspective, the landscape is such that you might want to take a look at your existing termination templates and really make sure that you're updating them to reflect that there will be certain payments that will be paid out regardless of whether or not they have executed the release for the enhanced separation package. And of course, working with your payroll teams, ensuring that the statutory payments and payments required under the ESA are processed as soon as possible once it becomes clear that a global resolution that you're offering is not being accepted. And as you all know, statutory termination and severance pay under the ESA in Ontario, for example, must be paid to an employee either 7 days after the employee's employment is terminated or on the employee's next regular pay date, whichever is later. So that's the first case. So good takeaway, refresh your termination templates to see whether they require updating. The next case is also, I think, a really interesting one, Humphrey versus Men. This is a 68-page decision, which I will hopefully distill down to a few punchy minutes. In this case, the judge awarded actually 12 months' notice to a 32-year-old chief operating officer named Humphrey, who had only 2.7 years of service. So the interesting thing about this case is that in December 2018, Humphrey had actually signed a new employment agreement, which included a termination provision. She was subsequently terminated in February of 2019 for alleged performance issues, and which we'll go into a little bit further shortly. At some point in the post-termination process, when lawyers were involved to effect some sort of resolution or an attempted to effect a resolution, the company basically withdrew the with cause termination argument and then tried to rely on the without cause termination provision. So one of the things I will also note, and that factored in the court's decision-making process, was that the new employment agreement that this individual had signed in the course of her employment, she did not receive any additional consideration for it. There was no increased compensation, no benefit in exchange for it. So the court at the outset really noted that the termination provision was void for lack of consideration. So obviously, everybody here knows, like anytime you want to try to introduce a new employment agreement, especially that you worked on carefully with robust termination provisions, especially if we're dealing with an existing employee, we need fresh consideration. So that's very important. So that didn't apply here. Notwithstanding this finding, the court went on to consider whether the employer's conduct constituted repudiation, which would have precluded them from relying on the termination provision had it been enforceable. So the interesting thing around that led to the termination is that in January 2019, before she was terminated, Ms. Humphrey had actually asked for a review of her salary. In response, the employer started questioning her dedication to the business. After she followed up again on the salary increase, she was removed from her position, provided a letter suspending her employment for 2 weeks while they decided whether they were going to demote or terminate her. Then the employer engaged in all this other problematic conduct, from telling other employees and clients that she no longer worked there and or that she was suspended. They restricted her access to business accounts. And so at the end of the day, the court looked at all these things that were happening and found that the workplace was toxic and that Humphrey was being mistreated based on the employer's conduct, which is considered hostile, belittling, and controlling, and due to the employer's abusive communications. So in the court's eyes, the court actually viewed that her suspension alone amounted to fundamentally change the terms of employment and that she was constructively dismissed when she was given the suspension letter. The court also found that there was evidence that the employer's conduct breached the fundamental and implied terms of any employment relationship, which is that the employer will treat the employee with civility, decency, respect, and dignity. So by the time February 2019 rolls around, the employer formally terminates her on a with cause basis. This allegation was revoked after the employer advised that the documentation that was related to her alleged performance issues had been destroyed. The employer had, in fact, found out that the documentation no longer existed once the parties started doing some negotiations and dealing with the litigation in July 2019, but didn't communicate to this individual or her legal team in January 2020 that they were going to revoke the with cause argument and then try to rely on a without cause provision under the employment agreement. So what the court found, based on looking at the totality of the circumstances, was that the employer was actually trying to look for evidence to support a for-cause termination, where cause just simply did not exist, and which was consistent with her bad behavior and was really penalizing her for asking for a raise. So the court essentially found that the employer's conduct here demonstrated that it no longer intended to be bound by the employment agreement and therefore repudiated it. The conduct, of course, included the toxic environment that we talked about, the humiliation and the embarrassment, and then, of course, exaggerating issues that were in support of the termination and alleging cause when it knew or should have known that there was none. And as a result, the employer in this case would not have been able to rely on a without cause termination. And Humphrey was then rewarded $50,000 for aggravated damages and $25,000 for punitive. So really the key takeaway here is that the Humphrey case does suggest that an employer may be able to rely on a without cause termination provision, even after the originally alleged cause. However, caution is advised because an employer's conduct may be used by the court to justify voiding the employment contract based on repudiation. And so such conduct, of course, includes alleging just cause when the employer should have known or knew that the cause argument simply didn't exist. So in other words, don't spend all that time getting in place great employment agreements to get and then have them voided based on repudiation by having a poor kind of conduct in terms of how you deal with an employee. And, yes, Lisa?
I think there's another lesson learned in this case.
Yes.
Never take a job from a company called Mean or maybe Mean.
That's right. I love that. And then the third case to round out this segment of the presentation is this, the Pohl versus Hudson's Bay Company decision. And so here, I mean, the employer's decision to escort a long-serving manager out of a store after he was fired without cause and had been accused of no wrongdoing attracted $45,000 in moral damages from an Ontario court. And that was on top of, the 24 months of notice and an additional $10K in punitive damages for delay in paying his entitlements under the ESA. So in this case, I mean, Mr. Pohl, he started working for the company back in 1992. I mean, over the next 28 years, he worked as a sales manager of 8 departments at the store in Toronto's Eglinton Square Mall. On September 15th of 2020, the employer terminated his employment without cause. Although it didn't assert any misconduct on his part, it directed the supervisor to immediately walk him out of the front door. So on termination, and as an alternative to a separation package of 40 weeks that the employer did offer here, they also offered him continued employment as a sales associate lead on the condition that he voluntarily relinquish or resign from his current job. In the associate lead role, the employee's weekly hours would range from 28 to 40 hours, no guarantee of minimum hours. He would be paid $18 per hour, and then the condition was that if he took this job, the employer could terminate his employment at any time without cause by paying him only statutory minimums. Obviously, as can be expected, he declined, sued for wrongful dismissal. And so as part of his litigation, he sought $50,000 for the way his dismissal was handled, and he found a favorable year in the court. And the 4 factors that the court considered to justify an award of $45,000 in moral damages was that first, I mean, the decision to walk in out the door was unduly insensitive, especially for the fact that he is a loyal 28-year employee who had no misconduct. There was no justification for treating him that way. The second part was that the offer of the sales associate job was deemed by the court to be misleading, breach of the duty of good faith and fair dealing, and the offer was viewed by the court to have been carefully drafted to extinguish his rights upon termination. Third, the company here violated the ESA by not paying out the wages it owed him in a lump sum within the required period of time. Obviously, the court was very firm in its stance that compliance with the act is not an option and that the employer does not require direction from the employee to comply with the law. And fourth, the employer was required to issue a record of employment within 5 days of interruption of his employment. The employer did not do so. And when they were issued, they also incorrectly described the reason and stated that the recall date was quote-unquote unknown. The court said they should have stated not returning. And then the court, on top of the $45K in moral damages, went ahead and did $10K in punitive as a result of the employer's failure to pay the employee's wages pursuant to the ESA, or on repeated demand by counsel for the employee, as well as the employer's failure to issue a timely or correct ROE. So, obviously when we're talking about terminations, a lot of times when we get calls, we're really focused on discussing what's the appropriate package, what are the notice entitlements. And when I think about this case, I mean, I really do think that it also highlights the equal importance of good faith and sensitivity, both during and after termination. And the significant ramifications of failing to do so and meet those standards. So one of the things as a takeaway is that employers really ought to recognize the distress, vulnerability, and humiliation that's often experienced by employees who are being terminated and respond in a delicate manner. From speaking with clients and many of you, at the end of the day, you all are very sensitive to these issues and will continue to be. And I think that to the extent you're working with your teams and managers who are assisting you on terminations, absolutely, I mean, it's important to continue to keep that in the back of your mind. Proper conduct by an employer is expected, not only at the time of termination itself, but also after termination, specifically with regards to fulfilling ESA obligations within the timeframes and the prescribed manner. So I'm sure we're all going to be vigilant about making sure that happens in light of these 3 decisions. And with that warm-up, I will turn the table over to Greg to talk about constructive dismissal.
Thanks, David. And just to reiterate, I mean, from these couple of cases, a lot of the conduct that the courts didn't like seemed like pretty sort of standard, not necessarily the best way to go about it, but pretty standard practice. Like if you're just walking an employee out the door after terminating them, that's fairly standard. You're not going to want them to stick around for long. Something like failing to issue an ROE promptly as well. Obviously, it's a pretty quick turnaround, 5 days that you're supposed to be doing that. Oftentimes, that doesn't always happen for some sort of administrative reason. So I think it's just sort of a good reminder to make sure that you have those processes in place, that you know that you do have that obligation, for example, to file that ROE very quickly after the termination, or else you could be slapped with a pretty significant damage award at the end of the day.
Certainly, yeah. My thought was on the severance piece. I was surprised by that decision. I think it's a fairly common practice that if you're having productive settlement discussions and you've offered something that is much greater than the ESA requirements, that you're providing a greater benefit. And so I was, for an award like that for moral and punitive damages struck me as a little tone deaf, and maybe a judge who's not as familiar with the kind of practices that we have. It seems to me that for the most part, it's a benefit to an employee to have continued, we don't just pay out the ESA minimum and cut them off. Frankly, it's a bit of a pain to put them back on benefits, and it's in everyone's interest, if you're having productive settlement discussions, as I say, to sort of continue. But what struck me was maybe in light of this decision, what we have to do is more proactively, and as lawyers as well, if there's a specific request from counsel for the plaintiff to have the lump sum severance payment made, to do that. But also maybe we have to proactively reach out and say, it would be our expectation and intention to, while we're having productive settlement discussions, to, keep you on salary, keep your, your client on salary continuation. And do you agree, or would you prefer? So I think that in the interim, I don't know. I meant to look up to see whether they were going to appeal it or not. I don't know if it has been appealed, but it struck me as, this is a decision that, from a judge who doesn't really understand what we do practically, frankly. And so that's my 2 cents. Sorry to jump in.
No,
But I always have 2 cents. But
No, I think it's...
Hugh?
Yeah.
I was just going to ask about that fourth point about offering the lower-rated position with no guaranteed hours. And I just wondered, this was a case like that in Nova Scotia where the judge just went to town on the Halifax Herald that had done the same thing and had this statement that you just don't treat people like that. And I kind of wonder in this case, did that sort of initiative, if I can call it that, by the company lead to a very bad light within which the rest of their case is being evaluated by the judge? So probably not like a legal causation, but kind of just puts it in a bad light. I don't know if you've got any thoughts on that.
Really just didn't like one of the-
I always think the judges are, I'll let you answer that, David. I always think that it's a human, this is a human, judges
Yeah.
are human, and David's case that he's going to talk about at the end of our presentation is all we're going to leave on a really interesting case. 'Cause
For sure.
It's got all sorts of stuff. But it's very much a human exercise, right? So as you say, you wonder whether, sometimes courts do it by cost awards or they do it by punitive damages, but just sort of the bad behavior that is sometimes seen, for sure.
And on those same lines as well, Lisa, I see your hand up, but I just wanted to add kind of on that practical side, Hudson's Bay has had, a number of decisions over the pandemic against them. They've sort of taken a lot of cases all the way through. So could have also just been the court, wanting to sort of send a message to them that this isn't how you're supposed to treat your employees.
Agreed.
Throughout. At least I don't know if you had anything else to add.
That's an excellent point, because people might remember the headlines about Hudson's Bay paying the huge bonuses while they weren't paying their employees the wages during their CCAA proceedings. So yeah, there might be something to that. I was just going to say, so when you're in a trial, you can't give evidence of what severance offers were being made, right? Like that's all without prejudice settlement discussions. So it's likely that the judge, when they were writing this decision, wouldn't have known that there was a severance offer on the table. Like it's one thing. I don't think if you make a fair severance offer to someone to say, or if you want to stay, you do have this other job that's lesser. That I don't think there's anything wrong with that. But they may have had to go through the whole trial without being able to say, we offered the guy 12 months, he just wouldn't sign for it, right? Because you can't say that in trial. So that could have influenced as well. Or was there can you tell from the decision, David, if there was a? I'm guessing because they were doing the salary continuation and they hadn't issued the ROE, which by the way, it's 5 days from the cessation of earnings. So we only started
Yeah.
when they ended.
There's a lot of, I thought there was some technical problems with a lot
Yeah,
of decisions.
with the decision, agreed. So we'll see if other judges follow this. But I mean, I think the main thing about that case, though, was that there was a lot of strong pronouncements about good faith dealings that we should, generally speaking, be sensitive to, notwithstanding that we might not fully agree with the court's decision.
There's a question?
I just wanted to know, like, from all of the examples, it just sounds like the tone that you set when you are in front of the judge really plays a huge role in this. So it just seems like with every case, there's a lot of things that were not disclosed. Things were always done in what could have been assumed as bad faith, things like that. So I guess transparency is really key here, and also, you know, you play the devil's advocate, right? Like, you have to think of the extreme as well when you're going through these cases. And when you're, like, when I'm talking to the lawyer for advice and how we would handle this, it would be good not just to think about my own vision or the company's own vision, but just to have a broader sense of all the areas of good to, again, to always be transparent and not withhold things, because I think the worst thing you can do is probably shock or, you know, go in front of a court and the judge would suddenly hear things thinking, come on, you're telling me you didn't think about this, right? So it's sort of
Exactly.
like an avoidance thing.
Absolutely.
Is what it sounds like.
Yeah. And I mean, and that's part of the exercise when you're working with your internal teams and external counsel, when you're liaising with counsel for an employee who's not happy with the package, right? And we all as a group are very focused on making sure that when we do interact with opposing counsel, we're very proud of our reputations about being forthright and being strategic. And certainly when it comes to things like trying to negotiate a separation package, if it gets to this point where it's very clear that the global resolution is not forthcoming, you know, there's definitely discussions that I have with my clients about making sure, let's make sure that ESA payments are processed. Let's let them know when benefits are going to be, you know, ceasing at some point in the process, and providing that kind of fair notice, and so that both the company and us as external counsel maintain that good reputation, so that we are able to assist on other matters with the same counsel and hopefully affect positive resolutions. So I think your point is excellent. Yeah.
Great. With that, I think maybe we'll move on to the next topic. I'm going to be going through a few relatively recent cases on constructive dismissal. A lot of these are sort of decided in the context of issues relating to the pandemic. But I think, you know, with any of these cases, there are always lessons that can be learned along the way, whether it's, you know, related to actual COVID issues that you might be dealing with, or just sort of general principles going on in the background. So first, going to go through one of the issues that came up quite a bit at the start of the pandemic, and this was, you know, the question of whether in the context of COVID-19, does an employer have the right to temporarily lay off an employee, or does that constitute constructive dismissal? And while it may seem like employers should have some sort of ability to temporarily lay off employees when business is slow, unless you've actually got a term in the employment agreement, whether express or implied, that gives the employer that right. The law has generally been over the years that putting an employee on temporary layoff can lead to an employee, you know, credibly asserting a case of constructive dismissal. When the pandemic came around early 2020, businesses started closing their doors, placing people on layoff. Question essentially evolved into, you know, in these unique circumstances, does anything change? Is it still a temporary layoff, or does the employer have a bit more leeway in these circumstances? Now, on the common law side of things, and this is sort of talking, you know, it's one case if you have an express term in the contract that says you may, you know, lay the employee off at any time. But in the context of the pandemic, there have been a couple of cases that have dealt with this sort of, you know, implied right to lay somebody off. One of those cases in Ontario dealt with an employee who was laid off just sort of prior to when the pandemic first kicked off in late January 2020. Right when businesses were sort of starting to shut down, or business kind of went down, a lot of people were uncertain about what was, you know, going to happen in the coming months. Now, in that case, the company argued that even though there was no term in the employment agreement that would have allowed the company to temporarily lay off the employee, the pandemic was a unique circumstance where temporarily laying them off should not constitute constructive dismissal. Court disagreed, found that, at least in those first couple of months of 2020, it was no different than an employer facing a regular business slowdown, which in the past, courts have said, employer, tough luck, but you're going to be on the hook here either way. You still don't have the right to lay an employee off, stop paying them, stop giving them work. The court did, in that case, however, kind of leave the door open to this sort of idea of an implied right if it was due to government action, either shutting a business down or affecting operations to the effect of them not being able to actually keep these employees on at the time. So while those weren't the facts of this specific case, it at least sort of leaves that door open for any future cases that are decided within that context when the government had enacted legislation to actually close certain businesses down. There's another case in BC, came out mid-2021. It didn't go into quite as much detail on the issue or as much kind of legal analysis. But in another win for employees, court found that even though layoff during the pandemic might have been in good faith and they had good business reasons to do so, it didn't ultimately matter. Without an actual term in the employment agreement giving them that right, there was no right for the employer to temporarily lay off the employee, and the employee was constructively dismissed. On the statutory side of things, under the Employment Standards Act, where an employee is placed on temporary layoff, they can be on layoff for a specific period of time. It's usually either up to 13 or 35 weeks, depending on the circumstances, after which time the statute deems that the employee is actually terminated. It is important to note that just because the ESA has this sort of temporary layoff regime in the actual legislation, the courts have traditionally found that temporary layoffs at common law will still constitute constructive dismissal. And the issue became a little bit murkier when the Ontario government introduced infectious disease emergency leave in May 2020. And that regulation essentially provided that if an employee was temporarily laid off or if they had their hours reduced for a reason related to COVID-19, they would be deemed to be on a leave of absence instead of constructive dismissal, at least under the legislation. This saved employers from employees being deemed to be terminated and having to pay out termination pay and severance pay. But when the legislation came out, the question remained, does this affect the common law at all, or is this only limited to sort of this ESA framework that's in place? And we've had a few decisions on it over the past year and a half. First case that dealt with the issue, Catino and Ocular Health. This one came out April 2021. And notably, just a couple of months before this decision came out in February, the Ministry of Labor actually came out and said, our intention with this legislation was not to displace the common law. It's still, that can, sorry. It worked well. So government said the intention was not to displace the common law. This is only meant to apply to the statute, which obviously isn't a good sign for employers or a good sign for these cases coming up. So in that case, the employer argued that, given the severity of COVID-19 and its impact on many companies and the company's business, the changes should be interpreted to apply to both constructive dismissal under the ESA and the common law as well. The judge disagreed, finding that there was nothing in the legislation itself to suggest that it was also intended to take away an employee's common law right to sue for constructive dismissal. Just a few days later, the same court, different judge, came to the opposite conclusion, found that an employee who was temporarily laid off during the pandemic or for COVID-19 related reasons was not constructively dismissed at common law. The judge in that case took more of kind of a practical approach. They looked at the government's reasoning for introducing the changes to the ESA and the challenges that were faced by businesses during the pandemic. So in the court's view, government had essentially forced employers to lay off a number of employees by their actions. And in doing so, they exposed employers to claims for common law constructive dismissal. To avoid those consequences, in the court's view, the legislature changed the ESA, put this new regulation in place to basically solve the problem that the government itself had created. This decision was definitely a win for employers, at least at the time. But the plaintiff employee did end up appealing the decision, which we'll get to on the next slide. Now, a couple of months after those first two cases, we had another decision, Fogelman and IFG. swung things back into the employee's favor. So in that decision, court agreed with the decision in Coutinho, not with the decision in Taylor, and found that temporary layoffs during the pandemic still constituted constructive dismissal at common law. And then more recently, in May of this year, 2022, Court of Appeal considered the lower court's decision in Taylor. Many were hoping that the Court of Appeal decision would provide a bit more kind of definitive guidance from a higher court on how employers and employees should be navigating these issues. Ultimately, the Court of Appeal, they allowed the appeal, but it was on a technical ground. They didn't actually deal with the issue of, does a temporary layoff constitute constructive dismissal? Remitted it back to the lower courts with a new judge to hear it. So didn't really get any conclusion from that case. So as it stands, we have the two cases saying that employees can still sue for constructive dismissal, notwithstanding that we had these changes to the law. And then this sort of uncertain result from the Taylor case that's still sort of waiting to be heard. Could have been settled, obviously, in the meantime, so we'll wait and see on that one. But given how things have gone to date, still tough to say. Certainly possible that employees will still have the ability to sue for constructive dismissal as a result of being temporarily laid off. So, I mean, this means even if that's the case, employers still, may be able to rely on other arguments to fight constructive dismissal cases in those circumstances. That door, as I mentioned earlier, is still kind of open to say that maybe there was this implied right to lay somebody off. Will obviously sort of depend on the circumstances. If there was more government action involved, you probably have a better case. Or you can argue, depending on when the employee actually brought the claim, say they waited too long, maybe the employee had condoned being placed on layoff, might not be able to actually bring their claim for constructive dismissal. So to the extent any of you have any ongoing cases dealing with this specific issue, definitely still legal arguments to be made, even if this particular statutory issue doesn't look great at the moment. Yes, Lisa.
If there is anyone that, the one argument that we've been talking about as a group throughout that no one's really argued fully in any of these cases, or maybe it wasn't our task, is that there's sort of a potential frustration of contract argument. I think if you're just business is bad and you decide to shut things down, you couldn't really make that argument. But when you were ordered to shut down, like a lot of things were for a while altogether, that it's not the employer's decision, it's not the employee's, it's a third outside force that caused you to have to not be able, for the contract of employment to be impossible to implement, like on a temporary basis at least. And so we think that's a really strong argument. It's not a termination by the employer, it's a frustration to outside third party, albeit temporary rather than permanent, like we usually talk about. So we're still hoping that that argument could be successful if you might fall into that kind of argument.
It's interesting to see how the courts, though, are dodging and weaving.
Yeah,
Certainly in
totally.
Ontario, trying not to make a decision. It's frustrating if you're trying to advise your clients.
Yeah, the Court of Appeal, the parties had actually asked the Court of Appeal to opine on it because they realized that everybody else in the province is still dealing with the issue. But as Christine said, the court kind of dodged the issue, said, take it back to the lower court and you guys decide there. So kind of surprising that we haven't gotten more guidance from the court, given that we're now, late 2022, but could just be parties not really wanting to be the first sort of test case to go forward.
But there's hope
There always is.
in this case.
So next up, we're going to talk about a couple of relatively recent cases on the issue of whether placing employees on unpaid leave for not complying with workplace policies constitutes constructive dismissal. This first case, Benke and Loblaw, involved an employee refusing to comply with the company's mandatory masking policy. August 2020, the company had implemented a masking policy in all of its stores across Canada. It applied to both customers and employees, also provided exemptions for people with underlying disabilities that prevented them from being able to wear a mask. Employees who refused to comply with the mandate would be placed on an unpaid leave, but they could return if they elected to wear a mask in the workplace. Now, this particular employee refused to comply and was placed on an unpaid leave. In response, the employee sued the company, alleging that having been placed on unpaid leave, he was constructively dismissed. Court ultimately found that placing the employee on unpaid leave in these circumstances was not constructive dismissal, so definitely a win for employers. In coming to this conclusion, the court first found that the actual requirement of the policy, the requirement to wear a mask, was not a substantial change to the employment relationship and did not breach the employment agreement. Court found that the employee's job responsibilities didn't actually change. At the end of the day, the only requirement was that he put on a mask while performing his regular job duties. Court then considered the employer's decision to place him on unpaid leave. And while the court found that doing so did constitute a substantial change to the relationship, there was no actual breach of the employment agreement. Court stated that the essence of the employment relationship is that the employee will work and the employer will pay. And given here that the employee was not working by reason of his own voluntary choice not to comply with the reasonable mask mandate, it was reasonable for the employer not to pay him. Court had actually found that the employee had repudiated the employment relationship by refusing to comply with the masking policy, and that the company could have treated the relationship as at an end at that time. But instead, the company decided to keep him on unpaid leave, keep him employed, sort of kept apprising him throughout the time while he was on leave that they considered him still an employee. And either way, the employee was ultimately unsuccessful in his constructive dismissal claim, and the court found that he had resigned. Case definitely helpful for employers, provides authority for the position that these sort of COVID-19 related policies or even other related policies in the right context can be seen as reasonable. When an employee refuses to comply, company potentially has the option to treat the employment relationship as at an end on the basis that the employee repudiated the contract at that time, or provide some support for the ability to place an employee on unpaid leave until such time as they end up actually complying with the policy. We've got a similar case more recently. This one was out of BC at the end of September. And this one was about a mandatory vaccine policy. This was sort of the first decision that dealt with this issue in the court context. There have been a number of arbitration decisions over the past year and a half or so now dealing with the reasonableness of these policies, but this was the first one dealing with the question of is refusing to comply with a vaccination requirement and being placed on unpaid leave constructive dismissal. In this case, the employee was an accounting professional. They worked for a property management company. Late 2021, the company put in a mandatory vaccination policy, as many others did, which had required that all employees provide proof of vaccination, failing which they would be placed on an unpaid leave of absence. The employee said she wasn't an anti-vaxxer, but she didn't want to get the vaccine because she was concerned about potential negative health effects that could result. Now, instead of getting vaccinated, this employee had proposed a number of alternatives. She had proposed, can I work from home on a full-time basis? I can do some sort of hybrid arrangement. Happy to take tests anytime I need to come in to meet with, other employees or clients. The employer denied her proposals, basically said, there are going to be no exceptions to the policy. We're applying it across the whole company. And when she missed the deadline for providing her proof of vaccination, she was placed on an unpaid leave of absence. Now, the employee argued that as a result of being placed on that leave of absence, she was constructively dismissed, and that the policy was unreasonable because it didn't make any exception or distinction for employees who were working from home or who could work from home. The court disagreed, another helpful decision for employers, found that the policy itself was reasonable, was a lawful response based on, the uncertainty that was the sort of circumstances of the time based on the pandemic. And especially in late 2021, when we were starting to see, an uptick again in, or another wave in sort of late 2021, early 2022, when that policy was introduced. The court liked that the policy provided for regular reviews, so it wasn't a, here's the policy forever and that's it. They liked that the employee wasn't replaced. The employer's position throughout was that, you can come back as soon as you get vaccinated. I think it helped as well that in terms of the reasonableness of the policy, she was actually the only employee of something like 200 who didn't comply. So the court took note of that too and said, if there's only one of 200 of you, maybe this is a reasonable policy here. It's not that half of the company sort of refused. Court ultimately found that placing the employee on leave was not constructive dismissal, and then she had actually resigned by taking the position that she had been constructively dismissed. So, in terms of takeaways, to the extent you're dealing with this type of issue still, if you have any ongoing cases, Definitely helpful for the argument that these policies are enforceable and that putting employees on leave for non-compliance may not constitute constructive dismissal, whereas pre-pandemic or in different circumstances, maybe simply not paying somebody, putting them on layoff or putting them on a leave of absence certainly could constitute constructive dismissal. Obviously, every case is different. It'll depend on the circumstances in your own workplace and the policy and the sort of prevailing COVID conditions at the time. But I think definitely helpful overall, just for sort of upholding those policies and fighting back against any constructive dismissal claims that do come up. Now, the final case on the constructive dismissal topic that I'm going to talk about deals with how quickly an employee needs to allege that they've been constructively dismissed. This one's not in the context of a leave of absence for refusing to vaccinate or wear a mask or anything, but these sorts of cases don't come up all that often, but this one was particularly helpful, just a recent one that came out of the Alberta Court of Appeal. In that case, the employee was a senior engineer. They had worked for the employer for 7 years. In response to the pandemic, the company had implemented salary reductions and cut off certain benefits for employees. Sort of early on in April 1st, 2020, the employer put these changes in place. 3 weeks later, the company went ahead and terminated a number of employees, including the plaintiff employee in this case. Trial judge found that the employee was constructively dismissed as of April 1st when those changes were first put into place. As a result, they were awarded damages for a common law notice period, and those damages were based on the employee's sort of pre-reduction salary. The employer appealed. At the Court of Appeal, court reversed the lower court's decision, found that by not objecting to that salary reduction or having resigned and sued for constructive dismissal during that 3-week period, the employee had actually accepted the change, condoned the employer's unilateral reduction of their salary, meaning she could not now assert that she was constructively dismissed. She was still able to sue for wrongful dismissal because she didn't have a termination clause in her contract that limited her to any amount, but the court ultimately awarded it based on the reduced salary rather than her pre-reduction salary. Well, in this case, it was a very short period of time that the employee had to make a decision. Court noted that there's no bright line test for how quickly an employee needs to allege constructive dismissal before they'll be found to have condoned the change. In reality, it's going to depend on what the actual change is that you're putting in place here. I mean, if you're ever doing unilateral salary reductions, this case definitely helpful for the idea that the employee should object, very soon after the change, or else they risk, essentially just being kept at that new salary and they can't later sue, saying that they were constructively dismissed. If you're dealing with something else, like say a change in job duties or even something like a demotion, employee may have a bit more time to sort of try out the role. Employer may not be quite as quick to say, the employee condoned the change. Maybe you've got more than 10 or 15 days. Maybe it's a month. Maybe it's longer. Obviously, sort of depends on the actual circumstances that you're dealing with. And another point from this case was that this employee was a senior engineer. The court specifically noted that she may be more sophisticated than other employees, so the court held her to a shorter period to accept or reject the change than might otherwise apply to an unsophisticated employee. So if you're dealing with an unsophisticated employee, maybe they've got more time as well before sort of losing that right to sue for constructive dismissal. So overall, if you're looking at implementing any sort of unilateral changes or substantial changes to employees, be mindful that they probably do have a bit of leeway before they need to quit and claim constructive dismissal, but will always sort of be assessed on a case-by-case basis. With that, I'm going to turn things over to Christine to talk about her favorite topic.
Assigned by Greg.
Assigned by me unilaterally for the enforceability of termination.
Is my Ronco case. This is my Ronco case in the Court of Appeal in Alberta. It was exactly my case, but they didn't cite it, so that was annoying, but that's okay. So this is a sad story, I think, in terms of there's been a roller coaster in the last number of years since we last gathered. I think we spoke about this in our May 2021 session, so I'm not going to prolong the discussion about Waxdale, but it has had a sort of fairly serious impact in terms of how we as practitioners have responded to it because it was a bit of a surprise. And of course, we draft our employment agreements and our offer letters in a certain way, and then the Court of Appeal makes a, when they approve a clause, we go back and look at our templates, and this is the clause that's been approved by the Court of Appeal. And so, and then 2 years later, they make a change, and we always try, but of course, you're drafting at a time when you're making offers, and then those offers are being assessed down the road. And so this was a really odd decision. I'm not going to talk about it too long, it's just because we've talked about it before, and I think everyone here probably knows about it, but it was such a strange decision because, it was the plaintiff here, he was a very short service employee. He lasted in director of sales position for about 10 months, I think. And he was making a substantial salary and had signed on in an offer, and obviously he was terminated before the court. The employer lawyer agreed that the just cause provision was contrary to the Employment Standards Act. It was unenforceable, illegal, but the court didn't cite it. So we were all wondering, well, what made it so? And ultimately we got the materials so that we could see, and it was a long laundry list, as you sometimes see in agreements, that goes beyond that sort of willful misconduct that we'll talk about later in a few minutes, if we don't get cut off. And so ultimately, at the end of the day, what the court said is, listen, you have to look at through the prism, as I often say, of the ESA being remedial legislation, and that, and I should have said also that the plaintiff's lawyer, Mr. Waxell's lawyer, agreed that the without cause termination provision was enforceable. So they were making very, so he agreed, which is a strange position. Yes, he was terminated without cause, and the without cause termination provision is enforceable. Not something you would expect. But that went on to say, however, because the just cause provision is unenforceable, it renders the entire clause unenforceable. And ultimately, the Court of Appeal, looking as it is through the perspective of the prism of the ESA being remedial legislation, ultimately agreed and said that if one aspect of the termination provisions are unenforceable, the whole thing goes out, and awarded ultimately damages on a common law basis. So that was a bit of, as I say, that was a bit of a shock because it wasn't, we typically, please. No, they just went on and on to say that if it's illegal, if it's contrary to the act, that the severance clause is not going to save it. So they specifically addressed the severance issue because that was argued ultimately. So we all, I think, certainly all the employment agreements we now have are taking a look at those. And I think it has always been good practice not to have those long laundry lists of things that, that's never necessarily good practice. But for those of you who still have, if you're looking at your templates, it's a good time to take a look and look at your just cause provisions. Now, moving on, there was a ray of hope. We were all very excited when the trial decision in a case called Farah Rahman and Cannon Design. We were all like, oh, thank God, like some sanity has returned. Justice Dunphy, who he has a history of, I think, making some fairly practical, I think, decisions, certainly in the vaccination space as well, which we can come back to, but he sort of said, one of the things in Waxell, the Court of Appeal referenced was the imbalance of power. So I just want you to remember imbalance of power. Because, so in the trial decision, he looked at it and said, now, this was a sophisticated senior person in Canada. She was 61 when she was offered the job. She was clearly a leader. There were some common employer issues, which it's not relevant for today, but approached through the U.S., given her expertise in the industry. She was made an offer. She had counsel. They negotiated the offer. There was some question about, as Lisa mentioned earlier, privilege and how much was before the court, but, ultimately, the judge decided that she had received good and had no reason to doubt the competence of the advice she'd received. And so the imbalance of power didn't seem to be an issue for this court. And he kind of relied on and sort of said, listen, this is a sophisticated person who had counsel, who negotiated improvements to her agreement. And so he didn't feel bound by Waxdale and sort of made a decision that, it wasn't as sweeping as many of us agreed. So that lasted for not very long because the Court of Appeal got their hands on it and said, no. Again, just going back to the severability clause and to the extent that it doesn't matter that you got advice and that you negotiated, if fundamentally the clause is contrary to the Employment Standards Act, then that's the end of the day. You're done. Like she's not to be held to it and is able to negotiate or able to be awarded the common law damages. So that was sort of, we had sort of a brief reprieve for about 8 or 9 months where we thought maybe we were able to see some confidence and sort of practical approach to these things, but to no end. So we were left with Raman, and unfortunately, we'll come back to Raman because in one of the decisions that we're going to talk about, it was like literally the day after the Court of Appeal decision was released. there was a trial going on where this was an issue, and unfortunately, the trial the employer was relying heavily on this Dunphy decision to sort of say, listen, here it's a sophisticated, this is not a power imbalance. But unfortunately, the timing of these things is such that the Court of Appeal put an end to that decision. So ultimately, as the slide says, the Court of Appeal overturned the lower court's decision, and the level of sophistication has no bearing on whether a termination clause is enforceable. So we're back to Waxdale. In the next decision, this is interesting because it sort of takes it to the next step. I'm not going to take long on this case, but this was a decision involving some. There's a lot of dentist decisions for some reason, but they just do not want to pay their staff. They go out of their way to create all these circumstances. But again, I'm going to mention Ronco again because they did what the Court of Appeal in the Ronco decision suggested, which is they were winding down their practice. They were about to retire. And so what they were doing was they have all these existing employees, and what they said to them was, we're gonna change the terms and conditions of your employment, and here's what we're gonna propose. If we'll give you $500 if you'll agree to it now, as consideration to make it effective, or we're gonna give you working notice, and then we're gonna offer you these terms at the end of your working notice. And this particular person agreed. She agreed to it. But when it came time, and they did, ultimately then retire and terminated everybody, but she challenged the employment agreement, which had a termination clause, an ESA termination clause. And strangely, the termination clause itself was found to be valid and enforceable, again. But the strange thing was in the conflict of interest and in the confidentiality clause, it said, if you breach these clauses, we're going to terminate you for cause. And so it was a little bit more sweeping, and the court was like, well, we don't know whether it would have been willful, it's not really clear. So the conflict of interest provisions, it wasn't even the termination clause was actually quite valid and enforceable. So, ultimately, again, the clause was held to be unenforceable. So we're running out of time, so I'm just going to quickly go to the next one. This is just a cautionary tale. Again, this is an owner in context of a sale of a business, sold the company, but then it's not unusual for fixed-term contracts to be negotiated with former owners so that there's a transition with their expertise, et cetera. Again, the for-cause language was the issue. And so the contract, they terminated him 1 year in to a 3-year term. And the thing about fixed-term contracts that you have to really be thoughtful about and be careful about, and the Court of Appeal has opined on a number of occasions, most recently in Howard and Benson, is that, you know, if you do something that is, or if you have a contract that's not, if the early termination provision or the without cause provision is held to be unenforceable, then there's no, like, you're responsible for the balance of the fixed term. So it's a big whopping, and this guy was making a lot of money, so you can see the award was, you know, so he was fired, you know, essentially within a year or a year into this 3-year term, and he was awarded for the whole balance of the term. So it's just, when you're dealing with fixed term contracts, it's really worthwhile pausing, thinking about it, getting some advice before you pull the trigger on a termination. Take a look at your termination clauses. Are you at risk of it being found to be unenforceable? Because everybody needs to know when you make a business decision, and it may have been they decided to make the business decision, but also when you're negotiating, right? Like, do you have a strong case or do you not have a strong case, kind of thing. So those are the things that you need to think about. Lisa?
I always think, because of this risk, I always think if you have a fixed-term contract that actually has an early out clause, it's not really a fixed-term contract at all.
No,
If the
you would
parties
think so.
can terminate earlier. So maybe it's better just not to try to have fixed-term contracts and just have an indefinite contract.
I 100% agree. So I think there's, you know, in the healthcare sector, there's a lot of fixed-term contracts, and I always say, I'm not really sure, like, I always try to persuade people to just do like an indefinite term, so then you can terminate them anytime. And, you know, everyone's clear about what the terms are. And you don't do ESA because they're not enforceable, you know, or you can try to, but by the time we draft a clause, it'll be, you know, some other court will have found it to be. So if you're dealing with executives, you know, like, give up on the ESA clauses is my takeaway. But so just moving on to, I just wanted to point out this case briefly, and I do want to have, David's topic is interesting, so I'm just going to quickly say there is some good news. I want to end on a good news thing. Battison is a case where, you know, everybody, the incentive pay and bonuses over the notice period, and whether, you know, stock option plans, you know, all of that, when you're terminated, are you able to draft an agreement that is able to restrict somebody's rights to get a bonus over a notice period, et cetera? And in this case, Mr. Battison was 16 years. 16 years he was employed at Microsoft. For 16 years, he was given an award every year. For 16 years, he had to sign an acknowledgement before he got an award that he read all of the terms. And for 16 years, he, you know, absolutely attested that he had read and understood all the terms. And so, you know, he had completed them every year, but then, of course, said when it came time on termination, I didn't read that. I just clicked. I didn't understand, like, oh, kind of thing. And so, you know, and that argument has worked in the past on occasion, I can tell you, to my detriment. And so we were all, again, Nafisa and I, madly, you know, okay, you're gonna initial here that you saw in this contract, you know, going out of our way because of the Battison case to make sure that the termination provisions were brought to the attention. So you're not going to get a future award of a stock award. You're not going to get, I mean, which would be ridiculous. Why would somebody get a future award if they've been terminated, et cetera? But, or over the notice period, you know, the vesting issues, it's forfeited. But the Court of Appeal overturned the decision and just sort of said, listen, this employee, you know, agreed expressly, and he can't put himself in a better position by, like, feigning that he didn't read it. So all that to say, the Court of Appeal sometimes gets it right, and this is a case that it's still important to make sure you draw it to people's attention. Like, I wouldn't rely on this entirely; it's good, but when you're drafting, make sure that there is an acknowledgement. Make sure it's not just a lot of companies that I work with or I've seen is, you know, the bonus issue is here's the multiplier formula, and it's just a email out without, like a disclaimer at the bottom, you have to be actively employed kind of thing. That's just not going to do it in our world. It does it in the US. A lot of US, that would be perfectly acceptable in the US, but it's not going to happen. In Canada, we have to be much more specific in terms of defining termination date more carefully. So anyway, so on that hopeful note that I ended on, I hope, I turn it over to David.
Yeah, so I'm gonna try to speed through this case very quickly, and I'd love for Christine and Greg to jump in, and then we want to leave a few minutes just for some question and answer. It really, essentially, I mean, the render decision at a very high level, my view of it is that it's a decision that really reinforces the importance of, at the end of the day, making sure you have workplace policies in place dealing with violence, harassment, bullying, that comply with legislation, and of course that you're vigorously enforcing it. I mean, I think all of us in this room recognize how important it is, and given the climate that we're in, to make sure that these policies are enforced. In this particular case, I mean, the Court of Appeal dealt with a manager with over 30 years of service, Render, who was terminated after a single incident of slapping a female subordinate on the buttocks. So the employer had in place the zero tolerance policy for harassment discrimination, a progressive discipline policy, which stated that where the misconduct is of severe nature, the progressive discipline may be accelerated to match the situation. And at the end of the day, the Court of Appeal agreed with the trial judge's ruling, dismissed the manager's wrongful dismissal claim, held that based on the individual's position of authority, his responsibility to maintain a respectful workplace, the sexual nature of the conduct, and his lack of contrition were sufficient to justify termination. So this is I think a case that has provides some strong statement from the courts in terms of what they view from workplace harassment, bullying expectations, and the obligations that employers have to maintain that health and safety environment. The interesting thing about this case, and it kind of full circle with the Waxhill decision, is that from the Court of Appeal's perspective, this is a situation where there was just cause under common law, but it didn't quite meet the threshold for the purposes of disentitling the individual to statutory entitlements under the ESA. And obviously under the ESA, cause has the willful misconduct reference, which is a higher standard than just cause, which is arguably a bit more fluid and has careless, thoughtless, or inadvertent conduct. And so at the end of the day, the Court of Appeal agreed with Mr. Render and his legal counsel's arguments that ESA termination payments were still owed to him because his actions, while not accidental, occurred in the heat of the moment and were not pre-planned. And so that's
He wasn't bad on purpose.
Exactly.
That's what the Court of Appeal said.
That's right.
Accidentally slapped her on the butt?
Yeah, and there was conduct in addition to that was
Right.
pretty bad, yeah. So-
How would you pre-plan a sexual harassment?
Well, we don't
I
know.
read the case, obviously, as we all
Yeah,
have.
yeah.
Yeah.
Obviously a provocative question, but how would you pre-plan? Like, what would be willful?
I actually think I think they misinterpreted the word.
Well, again,
willful.
yeah. And, it's come back to me, sorry, David, I don't mean.
Oh, no worries.
No, it's me classically interrupting, I'm sorry. But I had a mediation in a vaccination case where we terminated for cause, and, quite, the argument from the plaintiff counsel that I had to do some fast talking to get around was, seriously, she didn't get a vaccination? Like, okay, she didn't get her vaccination. That's just you saying that meets the willful mistake. Like this guy gets just caught. Like he gets his ESA, but she doesn't because she didn't. Well, get a vaccination. How can you excuse this behavior and not somebody who made a decision about their health or, and we managed it and we didn't pay ESA. We paid something, but not
Good.
even ESA. But still, it's a hard decision
Yeah.
then to say, well, what would be willful misconduct then, right? Like,
Yeah.
So sorry.
Oh, no worries. I totally agree with that.
And I'll just add, I think it's a great case for just common law cause in general, because oftentimes you'll hear us or anybody else say, it's such a high bar
Yeah.
to actually make out a case for just cause, unless you're talking, theft or, sexual assault or something in the workplace. This was a long service guy, clean record, single incident, obviously
Good
very
point.
inappropriate, but you almost think the court's going to say, okay, sure, it's a one-time thing, but was termination a step too far? So I think it's very helpful for that point where it's, okay, this was the only thing. There is just cause at common law. He's not owed anything under that. Obviously a weird decision on the willful misconduct piece and whether that gets followed will remain to be seen, but definitely good overall, I think, just for sort of the just cause argument. Lisa?
Yeah, I totally agree. Do you think it's like the Quorum is trying to cut the baby in half? Like, he's not gonna get this bigger common law now.
Yeah.
But he's a 30-year employee.
Yeah.
Well, that's what I was going back to Hugh's comment
Yeah.
about, courts are human, right? So it's
Exactly.
a 30-year guy, but it just creates such a terrible precedent for us, collectively, to have to
Totally.
deal with, right? Yeah.
Exactly.
His conduct afterwards where he was
Oh, well, that's, I think you're about to get to, but that's, yeah, the conduct afterwards.
Oh, sorry, we didn't really say more.
Yeah, there's more.
single incident.
Yeah.
Yeah, okay, single incident with
Yeah.
different aspects.
Yeah.
I know. Yeah, I mean, we can talk about this case ad nauseum, but we only have a few minutes before the next session. 4, Mary, thank you. What can we tell you
getting
about
stink-eyed.
what we talked about today? Any burning questions about employment law? Happy to answer.
The interesting thing about this case, again, what he was referring to is that and the council are both known to be very aggressive council. And I think, I don't know what happened necessarily, but it really de-escalated. Like, it really escalated beyond, people were pretty entrenched, and the employer, I believe it was the employer, but the complainant was also escalating in the background, but one of them hired a public, like a PR person, and was really in the press about it, and
The elevator, the case of
yeah, it was the employer, thank you. And the court really took a dim view of the antics, the PR antics around, they made it really into a circus. And the Court of Appeal, dealt with it. And so even though the company, there was ultimately there was a no-cost award. So the successful party got no costs as a result. So the court, I think, that counsel and nobody came out of this case looking very good. And I think it goes back to Hugh's comment earlier, is that, it is very much a human exercise in how you conduct yourself. And employers, I feel like the employers, we always have to sort of be perfect, right? Because the employees pick. And I think one of the themes in terms of the cases that as we reviewed them and we prepared is that, you're always defending. And so if you have an opportunity to show some grace or, to somebody who's being terminated, it's probably in your interest to do so as opposed to taking a more aggressive stand.
I'd be interested to know more about where the Paramount Resources case is at, only because, and you mentioned the imbalance of power. That's really the first thing that came to mind, because it was mentioned that the court found that she, didn't object to the decrease in her compensation for 3 weeks. I mean, in general, and depending, and so this was in 2022, I'm guessing a lot of this unfolded during COVID, and I think the main theme during COVID was the uncertainty of people's jobs and
Yeah.
layoffs and all this. And I think that many people who had to maintain jobs and work, especially if they were breadwinners or making a higher income of 2 partners,
Yeah.
were very much less likely to speak up in
Yeah.
a situation
Yeah.
where their compensation was reduced, also recognizing that industries are getting hammered and annihilated, based on the economy, and so they're
It was a
like,
very uncertain time.
where is my entitlement? On
Yeah.
the one hand, businesses are really suffering due to what's
Yeah.
happening on a global scale, and at the same time, I've been maintaining a certain salary, and it was also mentioned that she was more of a senior professional level employee. Well, from my perspective, oftentimes, if that's the case, male or female, if you're, making the higher of the income in a household, and that may not always be the case, but if that was the case, then maybe you are less likely to speak up, especially in an economy that's so uncertain, and that's like really the theme all across. So, I'm,
It's
imbalance of
yeah.
power to me
Yeah.
really stands out. I'm
Yeah.
interested to know where that
It
goes.
clashes with the concept of, like, what comes from my mind, and I'll let you jump in, it was your case, but certainly in the various recessions we've had in the past, it always is, I always think about, what's the management right? Like, what a reservation of management right to run their business, and I always have a very sophisticated green light, yellow light, red light, right? In terms of, that's not the best, but in terms of how much can an employer change the terms and conditions without triggering a constructive dismissal? And it's not always clear. And that case is sort of told from the perspective of the employer. Other cases are told through the perspective of the employee, which is when you're facing a change to the terms and conditions of your employment, you know, do you speak up? Do you condone? You know, the employer proposes a change or implements a change. You either have to accept the change, and if you do, condonation. Is it 10 or 15 days? I'm thinking 3 months, probably. You know, do you not accept the change and you speak up? And then it's back to the employer to say, okay, never mind, just, you know, wasn't. Or, you know, or do you sue for constructive dismissal? But I think that, I think in the context of COVID, you know, the courts are trying to strike a balance between employers trying to survive and keeping as many people employed as possible for as long as possible, but ultimately they made the decision to terminate her. But, you know, it was I think you pick up on, that's a live issue. I mean, you know, what should they have calculated on the basis of the lower salary? You know, as an employment lawyer, as a management side lawyer, I think, yes, she did accept it. But was it 10 or 15 days that they found? That seemed to be a little,
Yeah,
I'm not sure I'd give that guidance.
I think that was it was a surprising decision. It's a very quick
Yeah.
turnaround, obviously, for
Yeah.
anyone. Like, if you just picture your own salary being reduced, are you going to speak up in that short period of time? I think practically the employee was terminated 3 weeks later, so she was still getting a substantial award. So I think that's maybe why the court was a little bit more, you know, on the employer side to say, sure, you should have spoken up earlier. If the employee, you know, hadn't been terminated, it might have been a different story. You know, they would have said, sure, you have 3 months now to object rather than, you know, 10 days. So again, just that more sort of practical, wider view on it rather than just, you know, the narrow circumstances of the law.
It wasn't like she walked away and expected severance. She was terminated.
Yeah, exactly.
She was getting fair severance. She just didn't get the top up over the post.
Yeah, her damages award went
Again,
from something
human,
like.
right?
Yeah.
Judges trying to figure out what the right thing to do in a terrible situation.
Yeah, and I think
so they
that-
gave the employer a little bit of a break, but
Yeah, it was
not a-
100,000 to 90,000, I think, was
Yeah.
the difference at the end of the day.
But it's still pretty, like that entire area of constructive dismissal, and when does the employment relationship come to an end formally, is still very unsettled. And
Yeah.
the Potter decision, which is a leading case on constructive dismissal, the Supreme Court of Canada, there's a few paragraphs at the end where they talk about this sort of, and Greg and I have had a few conversations about, on some of our cases, trying to figure out, okay, well, when is that employment relationship formally coming to an end? And it's not settled.
And now we have all the constructive cases I've been seeing in the last couple of years. The employee goes off on sick leave, but then delivers the constructive dismissal card. So usually they had to walk out, right? So you could say, well, they're not coming to work, so it's a resignation. But they try and do this like in between zone. Well, I couldn't come to work because I was sick, but anyway, you constructively dismiss me, and they try and draw that out. So we're always like trying to pin their lawyers down.
Yep. Now, our time is up. Mary's had the time's up note there for a couple of minutes now. Obviously, I saw one more question over there. Maybe we can quickly, might as well, yeah.
yeah, and we'll stick around, so anyone can.
Curious, just in the time that we're in right now, have you had any cases where we're asking employees to come back to work in a hybrid environment and they're not willing to come back for many different reasons? Any cases that are coming up that you can share?
I think every person in this room is probably
Yeah.
facing that issue,
Yeah.
including us.
I don't think I've seen any.
I haven't seen the
reported
cases
decisions
yet.
yet, because those are going to
Yeah.
take
Yeah.
a year or two to show up, right?
Yeah.
But yeah, very on point issue that they're.
Absolutely.
sense of where they're going to land?
I think, my personal, I'm a bit of a hardliner. My personal view is, it was a term.
Of your existing-
Being able to work from home was a temporary thing.
Yeah.
And it never changed, it shouldn't have changed what a person's terms of employment were. If they were required to come into the office before, you're entitled to make them.
Yeah.
Yeah, I think that's right.
The interesting is all your employees who moved another hour or 2 hour commute and all of a sudden don't want to do it, like.
And I mean, I think we're also say, labor shortages. So the reality
Yeah.
is, do you have the right to do it, and can you survive it? and do you want to do it? And then every company has, it seems a different perspective, right? Some people are like, great, we can reduce our real estate footprint, or great, we can, you know what I mean? Other companies are like, nope, have to be back. So it's also a philosophy and a retention issue, I think, too.
Just aligned with that, curious to see, because in my previous employment, it was, we had a production facility, and then we had the admin staff, and then you have the issue of discrimination where production staff say, well, we could never work from home.
Yeah.
We have
Yeah.
to come in every day.
Yeah.
And now you guys are not coming back, but they're not
Yeah.
getting disciplined, and we are risking our lives, and we have continued to.
Yeah.
And I think we'll see some of that as well.
Yeah. Yeah, lots of distribution center, like that's, definitely, that's, but, and I have that from a vaccination perspective, right? Which is, they have, you have the policy that's applied to everybody, but the back office, there's an IT person and an HR person and who didn't want to comply. But it's, from the company's perspective, it was, well, we can't impose it on everyone else and then not HR in particular, right? So you have to be vaccinated. So those are employee relations issues, I think, almost more than legal issues, because you certainly have the right to require them to come back,
We're so used
in our
to
view.
trying to accommodate people that you're thinking, oh, I could accommodate somebody, but wait, but you have to stop yourself and say, well, is there duty to accommodate the person? If it's not based on religion or human rights to do something like that, then you don't, we could accommodate, but you don't have to, right? I think we jump right into accommodation because we're doing it, and we think about that all the time. Maybe more than
Great.
Well, as I say, we'll all be around.
Absolutely.
And,
It's our pleasure.
Doesn't actually start till 10:20, so
Oh,
it's a
okay.
break now, so you guys.
Yeah, happy to stay and answer any other questions. Thank you very much.
Thank you.